People with disabilities, older workers, as well as pregnant women are among new groups getting more protection against workplace discrimination. It's part of 20 recommendations released today by the Tripartite Committee on Workplace Fairness. Now, they're on top of the existing guidelines for fair employment practices and could be passed into law next year. For the first time, the report identifies specific characteristics to be protected against workplace discrimination, and these include a person's pregnancy status, caregiver responsibilities, as well as any disability or mental health condition. Protection also kicks in beyond just recruitment to cover all stages of employment, and these include training, performance appraisals, as well as promotions and dismissals. There will also be a wider range of penalties for breaches, from work orders and financial penalties to the current suspension of work passes. The employment claims tribunals may also allow victims to receive monetary compensation of up to $30,000. Now, on the other hand, it can also impose costs for frivolous claims. The recommendations will also prohibit retaliation against those who report cases of discrimination or harassment. Singapore currently has no legislation in place to protect whistleblowers. Still, the committee admits that certain exemptions have to be made. It recommends that small firms with fewer than 25 employees be exempted from the legislation for a start. It will also allow religious organizations to make employment decisions based on religion. The Manpower Minister says while the recommendations are an important milestone, this is only the beginning.
Rooting out discrimination is a whole of society effort. It requires knowledge, it requires understanding and ownership by employers, and the support of employees to promote harmonious and progressive workplaces. Laws and guidelines are not a panacea, but they are enablers for us to support this effort and to give protection as well as to shape mindsets.
WFL would enable appropriate and effective actions to be taken against errant employers to maintain a conducive business environment for the majority of employers who have been responsible. I'd like to emphasize that workplace discrimination has no place in Singapore.
Well, some firms that have already implemented their own measures against workplace discrimination say that they're happy to do more. And these include more inclusive hiring and support for vulnerable workers. But for other companies, one analyst says that they may find it difficult to even comply with the new recommendations. Clara Lee with this report.
At age 68, Edna Goh should already be retired, but the veteran service manager is finding it difficult to leave her job.
I've been working in the bank, UOB, for 51 years. After I hit my retirement age, I still want to continue because I want to keep my mind active and then meet some new friends, upgrade new skills, and at the same time meeting old friends too.
Madam Goh rejoined the UOB workforce under a program that allows retirees to take up flexible work with the bank. So far, more than 65 workers like her have tapped the scheme since its launch in November 2021. And to make sure such retirees are well taken care of, the bank also offers them healthcare benefits and insurance, which are typically reserved for full-time staff.
In one of its latest initiatives, the bank has also given the green light for female staff who are pregnant or have caregiving responsibilities to choose their own working hours. At the end of the day, it says it's all about sending consistent signals to its people of what is acceptable and what is not.
If we have cases of discrimination, then we have to take action very quickly and sometimes make it public as well, so that it's being used as an example of things that we should not be doing internally.
But one analyst says it may not be as easy for other companies to ensure an inclusive workplace.
For many smaller businesses, the mom and pop shop, the 5 head count, 10 head count, 50 head count, they may not have the luxury of choice. And that means they have to gravitate to, honestly speaking, whichever is the first heartbeat that walks through the door. And that in itself may not really align with what this legislation may have in mind.
He says there are benefits of having a more diverse workforce, but it will be up to those heading up the new recommendations to appeal to such smaller players.
And joining us now in the studio tonight to discuss the Labour movement's perspective on those recommendations, we have with us Patrick Tay. He's NTUC Assistant Secretary General. Patrick, it's good to see you again.
Yeah.
How do these investigations actually begin, and who is the burden of proof on? I mean, how much evidence do you really need to begin an investigation in the first place?
Yes, as part of the latest deck of recommendations, I think important for the complainant would have to prove two things. Firstly, an adverse employment outcome as a result of that act. And the other one is that adverse employment outcome does impact him or her in more ways than one. And then, therefore, also covers adverse employment outcomes that are prescribed in the protected characteristics. So these two areas, adverse employment outcome, as well as the adverse employment outcome in those protected areas, these two areas, and then the burden will shift to the employer, and therefore the employer will then have to prove otherwise.
Yeah.
And very, very important is that the evidence gathering, because as you know, this, as part of the recommendations, this eventually might be adjudicated at the Employment Claims Tribunal, and therefore it's incumbent on the complainant to gather sufficient evidence. Evidence can come in various forms. It can be written, documentary evidence, it could be WhatsApp messages, email exchanges.
What if it's done verbally?
So therefore, if it's verbally, I think important to have, for example, just as you prove in the court of law, sound recordings, or even witnesses who have witnessed the particular act or whatever message that was conveyed. I think these are important evidence together.
That's interesting to know on the complainant's part. Let's look at the flip side, the company itself. What normally happens to a company if there is a complaint about unfair work practices that are eventually found to be true?
Yes, I think as part of the recommendations, there will be a series of measures, depending on the severity of the breach. Yeah, if it's found to be true, and we classify them into the low, the moderate, and the high severity. And in instances where it's low severity, I think measures will be instituted to ensure the employer complies or introduce guidelines or procedures or standard operating procedures in the workplace to better their practices. If it's moderate, there may be administrative measures and penalties. Currently, there are already administrative measures and penalties in place, like work pass privileges, etc. And therefore, that may be one way of taking action for moderate severity cases. But in high severity cases, I think one of the recommendations is that Ministry of Manpower might even take civil action and haul the employer to court.
Before it gets to that stage, that legal stage of potentially entering the courts and going before a judge, mediation has an important role. What has the take-up for mediation been like? And might we see more opportunities for mediation training?
Yeah, at present, as in many of the current cases via the Employment Act, about 80% of them are mediated, and more often than not successfully. Even in the union movement, we have grievance procedures, as well as conciliation procedures to ensure we try to resolve things at the lowest level and go to alternative dispute resolution, such as mediation. So I think definitely mediation will be the order of the day. I think we try to resolve it at the lowest level, and where possible, 2 levels of mediation. If it goes to the Tripartite Alliance for Dispute Management or the Ministry of Manpower, that's one level of mediation that will be carried out. And even if it's escalated to Employment Claims Tribunal, there will be still compulsory mediation and then eventually adjudication.
Let's say an act of whistleblowing has taken place. All right, so let's set that scenario. What are the safeguards? Specifically, how can NTUC, for example, prevent further acts of discrimination or further acts of retaliation? I guess the question is, even after it's been resolved to some extent, whatever way, to mediation or otherwise, how do you then mend relations in that particular case so that, it doesn't happen again?
Yes, that's right. And the labour movement, as myself being part of this committee that's promulgated or looked into this deck of recommendations, have suggested, and I think we have recommended, to have some form of protection for the whistleblower. So it's quite watershed in the sense that we have sort of protected whistleblowers through legislation or through suggested legislation in this instance. And two ways of protecting. Firstly, protecting their confidentiality. I think that's very important because our surveys have shown that many people or employees are maybe afraid to step forward and report cases because they are afraid that they may be prejudiced against or even taken action against. So therefore, in this deck of recommendations, we have suggested for two areas. Firstly, protection of confidentiality. Secondly, protection from retaliatory actions by employers.
Patrick, we're moving towards legislation to improve fairness in the workplace now. Why is it necessary to go beyond the guidelines? Because we have had those guidelines, rather robust to begin with, but now we want to make it a legal requirement. Why are we going there?
Yes, at the base level, there's the Tripartite Guidelines on Fair Employment Practices. This piece of workplace fairness legislation will be on top of that TGFEP. I think there are a few reasons. Firstly, we want to send a strong signal to everyone, not just employers, but also society in general, that we do not tolerate workplace discrimination and unfairness at the workplace. I think that's number one. And second, of course, as part of this deck of recommendations, we have suggested a wider array of enforcement measures. And not just enforcement measures, but measures against, as I shared earlier, low, moderate, and more high severity breaches. And as well, as shared earlier, whistleblowing legislation in that sense to better protect those that come forward to report some of these cases. So these are some of the new, or should I say, reasons why we decided to push for legislation. But all said, I think very, very important that we try to resolve things at the lowest level, and we hope that legislation or measures against employers or would-be perpetrators using legislation would be the last resort. We try not to get there. I said generally employers have been pretty compliant and some fair, not just fair but progressive. We hope through this legislation to send a strong signal, and that's a sort of a deterrent effect to would-be offenders.
Yeah. Important to have those fair and progressive workplaces. Thank you, Patrick, for coming into the studios to share your perspectives with us on this work in progress with these recommendations. We've been discussing latest efforts to improve workplace fairness with Patrick Tay, NTUC Assistant Secretary General.